Everybody, it's Mike Kennedy, Vermont Bar Council. Friday morning, thought I'd do a quick little chat, maybe start a new thing where like coffee and ethics, some quick hitters. So I'm up early. Seems those birds are really taking to heart the early bird gets the worm thing, trying to outdo one another. That's why I'm up so early. Heading down to Montpelier soon. Going to go for a run when I'm there. Big day for one of my lawyer friends in Montpelier this afternoon. So congrats to you, my friend. Okay. So today, just an overview of the 7 C's of legal ethics. I'm going to share a quick thought on each, but here's the deal with the 7 C's. You know, the rules of professional conduct are too long. You know, they're over 200 pages in the green books with, you know, run-on sentences, subparagraphs to subparagraphs, you know, colons, semicolons, this, that, and the other thing, and a whole lot of comments that aren't necessarily written for an easy read. So instead of memorizing the rules, I think lawyers are better off trying to memorize concepts. And I think, well, what I've done is come up with this concept. Think of the 7 C's when you're thinking about legal ethics. And I think if you remember the 7 C's, those concepts, you go a long way towards the most important C, which is compliance with the rules of professional conduct. And that's what we want to do, right? Create a culture of compliance within the legal profession. So the first C, competence, very first rule, rule 1.1. I'm not going to go in depth into each of the C's. I'm just going to highlight them for you. So competence. To me, competence means you have to know your job and you have to do your job. That's the duty of providing a client with competent representation. Remember, in Vermont, the comments to the rule make it clear that competence includes tech competence, understanding the risks and benefits of technology, the changes in technology as they impact the practice of law. Competence also includes wellness and well-being, making sure that we are healthy enough to provide competent services to our clients. Second C, it's in rule 1.4, communication. Are you communicating to your client sufficient information to allow the client to make a reasonably informed decision about the representation? Now, I've said this often. To me, that includes not just things that happen after the representation starts, but at the very outset, communicating to the client reasonable expectations about what will happen throughout, the result, how long it's going to take, how much it's going to cost, how often they're going to hear from you. Those things are important to communicate, and communicating reasonable expectations can go a long way towards keeping the client from filing that disciplinary complaint against you or from becoming upset with you, which, you know, can then hinder the relationship. Next C, it's in rule 1.6, confidentiality. Think of this. There's no need to be talking about information related to our clients' cases, none. As the sticker that my dad used to have on the refrigerator says, quotes Albert Einstein, you will have many opportunities in life to keep your mouth shut. You should take advantage of them all. That, to me, encapsulates the duty of confidentiality. Remember, the duty covers all information related to the representation, not just privileged information. And there are only 4 exceptions. Client gives you informed consent to disclose otherwise confidential information. It's impliedly necessary to carry out the representation to disclose confidential information. Disclosures required by paragraph B. Those are the situations that set out certain crimes that a client might commit or intends to commit when you as a lawyer have a duty to disclose. And then the situations in paragraph C where disclosure is permitted. Again, some lesser crimes, as well as, for instance, you have a disciplinary complaint filed against you. You can disclose otherwise confidential information in order to respond to the complaint. But remember, when it comes to client confidences, that'll help you comply with the rule. Next C, rule 1.7, conflicts. Conflicts we could probably talk for hours on. My thought, the quick way to do I have a conflict? Trust your gut. If you feel in your gut, feel like there's something that's making it so I'm going this way when I should be going that way for my client, that's probably a conflict. anytime that you're not, you've seen the picture I have where I come to a dead end on a road tees out up in the islands, a road I run on often, and there's a great big sign. One arrow points that way, one arrow points that way, because that's your only choice. To me, if that way is where your client wants to be going, but that way is where either your personal interests are bringing you, duties you owe to another client are bringing you, duties you owe to the court are bringing you, duties you owe to a former client are bringing you, that's the conflict. But again, with conflicts, trust your gut. So often lawyers call me and say, hey, Mike, I think I have a conflict, but I'm not sure. If you think so, you probably do. Because remember, if you think you have a conflict, the person that's the source of the conflict is most definitely going to think that you have a conflict. So be very, very careful in those situations. Again, trust your gut. Okay, I got to stop to think now. So I've got competence, communication, confidentiality, conflicts, the fifth C. We skip ahead for a while. Rule 3.3, candor. The most important duty, I think, in the rules. The duty of candor to a tribunal, to a court, trumps all other duties. There's language in one of the comments that says, yes, lawyers have a duty to argue with persuasive force for their client, zealous advocacy, but not at the expense of candor to the tribunal. We will decide cases on facts, on the truth. Understand your duties when it comes to what are you required to do when a client or a witness for a client puts forth information that you come to know is false. Remember, the first step is to have a chat with the client. It's not necessarily to run right to the court. The duties are outlined in the comments to Rule 3.3. Okay, those are the first 5 C's. They're all mentioned by name in the rules of professional conduct. I've added 2 others. The first, commingling, does not appear. That word does not appear in the rules of professional conduct. Rule 1.15B, Rule 1.15 talks about the duty to safeguard client property. Paragraph A, lawyer's property shall be kept separate from client property. That's commingling. Don't mix funds. Remember, there's an exception in Vermont. You can put your own money into a trust account, but only in an amount necessary to cover reasonably expected bank charges and fees. So that means you cannot just dump in, I'll put 1,000 in, that'll be okay, that'll cover any costs I have. No, we have case law that says that's a violation of the rule. If you know that your bank is going to charge $50 per month in fees, put in the $50. If you know that they're going to charge around $1,000 a month, put in the $1,000. But the 2 have to be connected. It has to be, you can't just put in money to create that, what we would call a float, so that the account is constantly protected from being overdrawn. Finally, on commingling, remember, the Supreme Court has made clear that commingling is likely to result in public discipline. It's that serious of an offense, meaning there are many different cases, if you look through the reported cases on the PRB's website, where lawyers get what's called an admonition. An admonition is a sanction that does not identify the lawyer. There's language in a Supreme Court opinion that says when we're talking about commingling, mixing our funds with client funds, admonition likely off the table. We're going to go straight to at least a public reprimand, which is a sanction that will identify the lawyer. And the last C doesn't appear anywhere in the rules, civility. You've heard me talk about this all the time. I think we need more of it. I think a lack of civility is contributing to increased stress, anxiety, and burnout within the practice. People are being driven from the practice because they're tired of dealing with lawyers who frankly are acting like jerks. There is room, plenty of room to do your job competently and diligently for your clients, to argue with that persuasive force that I mentioned earlier without acting like a jerk. Treat people well. It can only help you in the long run. So those are the 7 C's. Again, I think they're just easier to remember those than to trying to get caught up in memorizing the rules. And that's all I have for a Friday morning. And I did this in one take, which I think is the first time I've ever done that in a video. So I should probably stop talking now before I mess it up and have to do another take, because my video editing skills are terrible. Lack of tech competence. Have a great weekend.